Here we go. Hello, everyone, and welcome to Connecticut District SCORE's live webinar on the new Connecticut data privacy laws. I'm Bob Hogan, the webinar coordinator and a business mentor here at SCORE. I'm going to be your host today, and our presenters are Cliff Ennico and Bud Freund, but unfortunately, as you can see, Bud is unable to join us this morning, so Cliff is going to carry the load. More on Cliff and Bud in just a minute, but first some brief information on SCORE. SCORE is a nonprofit national partner of the SBA and offers three primary value-added services to small business owners. We offer free one-on-one counseling, and you can access that face-to-face via video, telephone, or email. And you can also obtain a mentor by using the yellow bit.ly link that you see on the screen, or you can go to the SCORE website and click on the Request a Mentor link. Secondly, we offer a wide range of educational workshops and webinars like the one today. And lastly, we offer extensive resources on our website, including access to subject matter experts. If you're on our website, you can also access a large number of recorded webinars on a wide range of business topics that can be viewed on demand at any time. Just some logistics on today's event. We have set aside time for Q&A at the end of the presentation, and Cliff will take as many questions as we can at the end. If you have a question, though, you can type it in at any time using the Q&A button on the bottom of your screen. And as I say, we'll take as many as we can at the end. It's now my pleasure to introduce our speaker, Cliff Ennico. Cliff is a nationally recognized small business legal and tax expert, and is best known as the former host of Money Hunt on PBS, where entrepreneurs defended their business plans before America's toughest panel of experts. An attorney and small business consultant based in Fairfield, Connecticut, Cliff has helped launch over 15,000 businesses. He is the author of 16 books, most recently the Crowdfunding Handbook, How to Raise Capital for Your Business Using Equity Portals. While Bud isn't here today, Bud has been self-employed for 40 years after graduating from Ithaca College. His national and international assignments were from corporate magazine and public relations clients. He has been providing IT solutions to homes and small businesses for over 20 years. And as a certified SCORE mentor, he regularly presents technology webinars and workshops throughout Fairfield County. It's now my pleasure to turn it over to Cliff. Cliff, it's all yours.
Hey, thanks, Bob, and thank you for the wonderful introduction as always. And thank you to all of you today who are taking out an hour out of your busy lives to listen to a lawyer talk about a topic that is going to be a little bit more technical than some of the stuff that we do in our SCORE webinars. Those who've heard my webinars before, I like to talk more about things like marketing, selling, making money, and that kind of thing. But this is a more technical topic, and it's something that especially if you are doing business in Connecticut, which is, of course, where we broadcast from, you're going to have to deal with this, and you don't have a lot of time to get up to speed on it. So here are the usual disclaimers. The most important one, as always, is number 2. There's a very big difference between giving out legal information and giving out legal advice. There's a very big difference between saying, hey, this is what the law is all going to generally about, which is what we're going to be doing today, and here's Joe, what you should do, and Mary, here's why you should do something different. That's legal advice. I don't know any of you well enough to be able to give you one-on-one advice. Neither does Bud. If you listen to something here and you decide that it's a good idea and you do it and it doesn't work out and your business fails, you go bankrupt, your spouse divorces you, your kids don't want to talk to you, the dog pees on your leg, and you're living in a diaper box somewhere under the Brooklyn Bridge, you can't sue anybody. Okay. All right. So here, a little bit of background. I'm going to begin with a Shaggy Dog Story. I think it's important to stress, why is this important, Cliff? Why should I care about this stuff? I'm a small business. I'm a solo consultant. I mean, I only got like 5 clients. Why do I have to worry about data privacy? Well, here's why. A number of years ago, my brother-in-law had a dog, a cute little Pomeranian named Duffy, 6 pounds of pure unadulterated joy. We all loved this dog, and we spoiled the dog rotten, especially on the holidays, especially at Christmas Christmas time. Well, one year, I want to go back about 5 or 6 years or so. My wife was on a business trip. Her plane got delayed. She wasn't going to be flying in until Christmas Eve, which is when we went to my brothers-in-law's to celebrate, Italian-American family. We do the Christmas with the 6 kinds of fish, that kind of thing on Christmas Eve. We always did that every year. And of course, we always, bought presents for Duffy. Well, Dolores, so my wife said, Cliff, hey, listen, before she gave me a bunch of things to do. I'm going to be in late. We'll make tonight, but please make sure you go to the pet store, get a couple of things for Duffy. Well, I have never been in a pet store in my life. I didn't have pets as a kid or anything like that. I'm allergic to anything that has more than 2 legs, and there's even exceptions to that. But so I went to the pet store, found a nice lady, knew what she was doing, but bought a bunch of treats and chew toys and stuff like that. And at the register, the woman asked me, "Do you want to sign up for our affiliate program? You'll get emails from us from time to time." And I thought, well, if we're going to be buying stuff for Duffy on a regular basis, that's probably a good idea. So I put in the email address. Silly me. Well, I got to tell you something. All right, now keep in mind, now this is Christmas Eve. Okay, I get in the car and I look at my phone, and there's an email saying, "Congratulations on your new puppy." And it was from the company, the pet store chain. Okay, I said, I signed up for the affiliate program. That's what's going to happen. Within an hour, I had 4 emails and a couple of text messages too from companies that I'd never heard of saying, "Congratulations on your new dog. Would you be interested in buying a bed, for the dog?" And the messages just kept coming. By that evening, my wife finally did fly in, and we drove up to New Haven to my brother-in-law's. By that evening, as we were driving up there, I got a message from a company that I never heard of saying, "Congratulations on your Pomeranian." This company, whoever they were, it was a data miner of some kind, had looked at the things that I had bought at that store and had deduced somehow through artificial intelligence that this was a Pomeranian that I was buying the gift for, which was 100% right. Okay, that's why we care about this stuff. I mean, I had no idea that by clicking on that one box, I was opening myself up to all of this. And that is why we care about data privacy. And increasingly, you have to care about it as a business owner. You increasingly have responsibility for your clients' and customers' data. Up until about 2018, nobody really cared about privacy very much. It's been very unclear whether the U.S. Constitution provides a right to privacy. The Supreme Court has kind of waffled on the issue. They've never really come down one way or the other. But in Europe, very different story. The Treaty of Rome that created the European Commission in the aftermath of World War II provides residents of all member states a fundamental right to privacy. And that should not be a surprise to most people. After all, during World War II, they had to deal with the Gestapo. We did not. People breaking down your house at 2 o'clock in the morning and dragging you off to a concentration camp. Thank God we have never had that experience in this country. In Europe, they have. And it was a very vivid memory at that time. For 20 years, though, most web businesses only did pay lip services to privacy. I mean, virtually all my clients who had web-based businesses had a privacy policy, but there were holes in that thing that you could drive a truck through. The biggest hole was a hole that says we can share your data with any of our affiliates. And we didn't define who the affiliates were. They could be anybody. Anybody who pays you a nickel, for somebody's data, you sell it to them. That was a big hole in privacy policies for about 20 years. Fast forward to 2018, Europe takes the advantage here. Europe passes something called the GDPR, the General Data Protection Regulation. This is a regulation that requires all companies doing business in EU member states, including those based in the US, to respect the fundamental right to privacy in the Treaty of Rome. And it's extremely broad. The definition of doing business in Article 3 of the GDPR is extremely broad. It doesn't just cover companies that have a location in the EU, but organizations that target their sales to EU members. So let's say that you have a website in the US and you take out a domain name on a .fr domain name, which is France. Your website is in French, has sections in French, and your goods are priced in both US dollars and euros. Question, are you targeting your goods and services to people in Europe? If you are, congratulations, all 91 articles of the GDPR now apply to you. There is no small business exemption in the GDPR, which is to my mind the biggest flaw in there. They should have put something in there saying, if you're doing less than $1 million worth of business, we don't care about you. I mean, the whole purpose of the GDPR was to grab companies like Facebook and Twitter and Amazon that are clearly doing business worldwide and are making tons of money over there and aren't, being taxed or regulated the way they should be, perhaps in Europe. That was the goal, not to get little mom and pop businesses like yours caught up in this web. It is not clear whether the U.S. courts will enforce the GDPR in an enforcement action against a U.S. company. So far, the only litigation involving the GDPR has involved huge, giant companies like Facebook, Twitter, and all. In the event that a European company or a plaintiff's attorney goes against a U.S. company that does not do business in the European Union, they don't target European customers, we really don't know whether the U.S. courts will give extraterritorial application to the GDPR. Okay, having said that, though, most clients of mine that have significant contacts with the EU are making efforts to comply with it. They may not be doing 100% of what they should be doing, but they're at least paying some lip service to it so that they can establish some plausible deniability in case somebody goes after them. Fast forward now to 2020, California gets jealous. They say all these wonderful Europeans have all these rights that we don't have. We're going to adopt our own act. So they adopted a Consumer Privacy Act, which mimics key features of the GDPR. It was an absolute mess. No one could figure out what it's all about. So in 2020, I'm sorry, that should say 2018, California adopted this Consumer Privacy Act, and it was so unclear that California adopted a proposition in 2020 which significantly amended the California statute. So now we have at least some idea what the California statute was intended to cover. In 2021, Colorado, Virginia, and Utah adopted statutes mimicking key features of the California statute. And in July of this year, Connecticut joins the fray, one of the last acts of the current legislature. They adopted the Connecticut Data Privacy Act, which mimics key features of the Virginia and Colorado statutes. Do you see the domino effect here of what's happening here? Everybody's jumping on the bandwagon now. They said, you know what, California, yeah, it's a nice place, but they're crazy out there. We don't want to do things quite the way they do out there. We're going to adopt our own statutes. So now we have 5 states in the union that have data privacy laws, and more are coming. Congress is debating a federal privacy law, but it's an election year. I don't think anything's going to happen this year. All right, let's start talking now about the new Connecticut law. That's why you're all here. The new Connecticut law doesn't go into effect until July 1 of next year, July 1 of 2023. Please do not click off the webinar right now. Oh, I don't have to worry about this now. Okay, Bob. Please don't do that. You really need to listen to this. We're talking here about, 9 months from now, and 9 months goes by very quickly. Ask any mother about that. 9 months can go by extremely quickly. Okay. Businesses doing business in Connecticut need to prepare to comply now. And there are 2 things you may have to consider. You may have to make changes to your website design. We'll talk about that. That was going to be Bud's contribution to the program, but I think I can cover it. I have a lot of web-based companies, and I'm always giving them the same advice. Bud, by the way, is an absolute genius at this kind of stuff. Any really technical questions you have about what should I be doing to my website should really be directed to him, and he'll be happy to answer your questions. He's a very big SCORE counselor, very much a supporter of what SCORE does, and I will make sure you have his contact information at the end of this program. But more importantly, you may need to make changes to your terms of service and privacy policy, which is a lot of the work that I do for my web-based clients. Okay, who needs to comply with the Connecticut statute? Data processors and controllers. Now, this is something that goes all throughout privacy law. These were concepts that were created in the GDPR, the European law, from 2018. And every one of the states in the US have followed these definitions more or less. A data controller is someone who basically has your data and is manipulating your data in some way. They're the ones, think of the controller. This is not 100% accurate, but think of the controller as the company or the person that owns your data. and has responsibility, primary responsibility for it. So for example, when I went to that pet store to buy my present for Duffy and I used my credit card, the credit card company is the data controller. They're the ones that had access to my personal information, my credit card number, my social, all the things that they need to be able to provide their payment service that they do. That was the controller. A data processor is someone who interacts with the controller and has access to your data. So for example, the data mining company that took my purchase data from that day and decided that the dog that I was buying for was a Pomeranian, that company was a data processor. They were dealing with the information, the data from my data controller, for the credit card company, and they were the ones, the pet store company and all, these were the data processors that were taking that data and using that to try to sell me something. That's a good way. That's a little bit, if Bud were here, I'm sure he could poke holes in that a little bit, but that's the basic concept. It's a very basic concept too, because processors do not have the same level of responsibility legally that controllers do. Controllers have the lion's share of responsibility because they're the ones who have the relationship with you. They are the ones who you have given them permission to own your data and to use that data. They're the ones that have the bigger responsibility under Connecticut's law and all of the other data privacy statutes. It applies to persons who are conducting business in Connecticut or producing products or services targeted to Connecticut. Now, there's that concept again from Article 3 of the GDPR of targeting the thing. It's not just enough to say you're in business and somebody buys something from you who lives in Connecticut. That's not enough. You have to be targeting your products through your marketing efforts to Connecticut residents in some way. And there's a body of case law that has evolved over the last 20 years that talks mostly in the context of, does a court in Connecticut have jurisdiction over an out-of-state company that's selling stuff into Connecticut? There's a body of law that says if you are doing business legally in Connecticut or transacting business in Connecticut, or if you have nexus in Connecticut for tax purposes, if you're doing enough business here that you're paying sales tax or income tax to the state of Connecticut, but you don't have a physical location here, you probably are targeting Connecticut residents sufficient to be subject to the data privacy law. Okay, but the statute doesn't apply to just all those folks. There's a volume requirement. In order to be subject to the data privacy law, you must either control or process the personal data of 100,000 or more consumers annually, except for personal data controlled or processed solely for the purpose of completing a payment transaction. So that one-time, access, that probably would not count toward the personal data, although it would for my credit card company. Or you derive over 25% of your gross revenue from the sale of personal data and controlled or processed the personal data of 25,000 or more consumers. Now, these are pretty big thresholds, but keep in mind that, if you are a consumer-facing business of any kind, you probably will reach these thresholds. Notice, by the way, it's an annual requirement. You have to hit these thresholds, within a year in order to be subject to the law. But if you're a consumer-facing company, it's very possible. If you have, like the pet store, for example, they probably did have 25,000 transactions involving different customers. Someone has to do the math here and figure out whether you have gone over the threshold. Interestingly enough, Connecticut did this the right way, I think. In California, they set a revenue threshold. All companies that have over 25 million in annual gross revenues have to comply with the California law, regardless of how much data they control or process. Now, that to me is a little overreaching, but to be honest with you, probably not. If you're a company that big, most of your business comes from credit cards and other payment sources, so you probably are over the threshold in other ways in California. So here's the thing: in order to be subject to the law, you have to either be conducting business in Connecticut or targeting your products or services to Connecticut resident, and you must meet one of these two size requirements. Let's just call them. All right. Okay. a number of companies and data are exempt from the data privacy law. State and government agencies, isn't that great? The legislature doesn't have to, or government agencies, the DMV doesn't have to comply with the data privacy law, right? They would qualify, wouldn't they? Institutions of higher education. Basically, if you're dealing with data that is already regulated under a federal law, so for example, the Graham-Leach-Bliley Act, which covers financial data, credit card companies and banks data, or business associates that are defined under HIPAA. If you're dealing with healthcare information, you do not really have to worry about the Connecticut data privacy law. What the statute basically says is if your use of consumer data is already regulated under one or more federal laws, you do not have to worry about us on top of it. We'll let you go. Just comply with that and you're okay. So for example, the data of children under 13, there's a federal law that's been around since 1998. It's called COPPA, with very specific requirements as to what websites can do with information of children, under the age of 13. There are parental consent requirements and all that. As long as you're complying with COPPA in Connecticut, you don't have to worry about Connecticut's requirements on top of that. If you are not complying with COPPA and you are dealing with people that you know to be under the age of 13, well, then you are subject to the Connecticut statute. So my advice to you would be, if you're dealing with underage people as part of your business, make sure you are complying with COPPA, because the Connecticut requirements are a bit more restrictive on child data than the federal law is. Data processed or maintained in the course of an individual applying to or acting as an employee. So for example, if you're applying for a job, for example, your online application form and your online interview does not count for purposes of the data privacy law. Emergency contact information for an individual is not considered, here's the most important one: de-identified or publicly available information. We used to call this statistically aggregated information. So for example, the best way to illustrate this is with a questionnaire. Let's say I have a questionnaire on my website. I have 50 yes or no questions, and if you do the questionnaire, I give you something. Okay, let's just say we have that. The data that that 500 people responded yes to question number 17 on my questionnaire, that is not personal information. That's de-identified or publicly available information. It's just a statistic is all it is. The data that says of the 500 people that answered yes to question 17, 200 were male, 300 were female. That is de-identified information. It is not personal information. The data that says Cliff Ennico answered yes to question 17 is personal information. Anything that can be traceable to a specific information or a specific computer or cell phone is considered personal information. But statistical information, like those first two examples, those are not subject to the data privacy law. So the one thing you need to do in your privacy policy, and if it's properly drafted, it's already there, but make sure there has to be a statement in there that says de-identified information or statistical aggregate information we can use any way we wish, and we do not have to get your consent. We do not have to get your opt-in. We don't have to do nothing when it comes to that stuff. It's only, this privacy policy applies only to personally identifiable information that can be traced back to a specific individual. Very important. The Connecticut law and all the other data privacy laws too pretty much exclude that, except I'm not sure about California. But the point is that whatever else happens, you should be able to use de-identified information any way you wish. The last bullet, I think, is very important too. Information in the context of a business-to-business or employment relationship. The data privacy laws only apply to consumers, and that includes the GDPR as well. These are consumer protection laws. So if your business is exclusively business-to-business and the only contacts that you have with your customers and clients are business relationships, you probably don't have a whole lot to worry about here, at least under the Connecticut law. Under the California law, you might, but Under all the other statutes, you don't really have to be worried about those all much. What rights do the consumers have? Well, these laws, well, pretty much all of the 5 statutes that have adopted in the United States basically are the same here. They basically grant consumers the following rights: the right to access. They have the right to ask you, if you are a controller, are you processing my personal data? If so, I want to see it. I want to know exactly what you have on me, and I want to know what you're doing with it. Correction, the right to correct. The consumers have the right to correct inaccuracies in their personal data. There are some limitations to this because some people like to try to, like, how can I say it, burnish their resume online. And there are certain rules that prohibit that from being done. The right to deletion, the right to be forgotten. This was the biggest advance in privacy law in the GDPR, in the European statute. The European regulation introduced what's called the right to be forgotten, which was totally the opposite of the way internet law was in the United States for 20 some odd years, since the early 1990s. The Europeans say that, if you have data on there and that you don't want up there, you have the right to contact a website owner and have it deleted from that website's database. Now, that is something that the American statutes are adopting, but there's still some resistance to it. American internet law has always been opt out. We can do whatever we want to do with your data unless you specifically opt out and tell us we can't do it anymore. European law is just the opposite. It's opt in. It says, in order for us to do anything with your data, you must give us specific permission to do it. And there's a way you do that online. It's a very dignified data portability. You have the right to obtain a portable copy of their data to the extent technically feasible. They have the right to opt out of certain data processing for targeted advertising, the sale of personal data, or profiling in connection with automated decisions that produce legally or similar. What profiling is basically all about is that the computer builds up a database of information and makes judgments about who you are and what you are likely to buy. So, for example, that data mining service that identified the dog as a Pomeranian, that is somebody who definitely did profiling based on the stuff that I bought and said, this guy's got a Pomeranian. He's probably going to want X, Y, Z other products and services. Controllers have 45 days to respond. Keep in mind, controllers always have the lion's share of responsibility. If you are owning a customer's data and you have been given permission, by the owner to use that data in certain ways, you are a controller. You are not a processor. If you are a controller, you have to grant all these people these rights, and you have 45 days to respond, extendable one time for an additional 45 days as reasonably necessary. All right. What is a sale of data, by the way? We've been talking about using that term now a couple of times. Obviously, if you're a big company, this is how Facebook and Twitter and all the social media sites have gotten into legal trouble over the years. And over the last decade, the Federal Trade Commission especially has been very aggressive in going after these companies, because let's face it, after a while, when you have over 1 billion users, that data that's sitting on your website is one of the most important and valuable assets you have. And there are companies that will pay a bloody fortune to have access to that database of information. It becomes one of your major product lines. At one time, back around 10 years ago, Facebook made the lion's share of its money on, selling its data, its customer data to other people, because they don't charge for a Facebook page. They don't make money from their operations. They get it all either from advertising or from the sales of data. That's the only two ways a social media company can make money. What Connecticut has said here, the exchange of personal data for monetary or other valuable consideration. Now, those words are very, very important. There is the Utah statute says that for something to be a sale of data, there has to be actual monetary consideration. I have to take your data, sell it to somebody, and get actual cash money for it. That is not the case in Connecticut or Virginia or Colorado or California. In those states, and Connecticut has pretty much followed Virginia and Colorado for the most part. They didn't really follow California too closely. They did not follow Utah. Utah, being a red state, is a little, their statute is a little bit more business friendly. It's a lot easier to comply with than the statutes in California and elsewhere. Connecticut is sort of following the lead in Colorado and Virginia. So for example, there's a large bunch of activities that do not constitute a sale. So let's say, for example, that I am a consultant and I'm consulting for your company, and your company discloses to me, your company's having a problem with my software product, let's say, and we're trying to resolve it. We're trying to fix the bug, whatever it is. And you share with me screenshots with actual customer data on those screenshots. Am I now a processor of that data? Well, if you read the statute closely, the answer is, well, yes. But in the Connecticut statute, there's a specific disclosure that says the disclosure of personal data that processes the personal data on behalf of the controller is exempt from the Connecticut data privacy law, which I'm very happy for. Some of the other statutes are not as clear on this. And I have a lot of clients who do SaaS software services where they have corporate clients, and the corporate clients, that's no trouble. That's a B2B transaction. Nobody worries about that. But they have access to screenshots of actual consumer data that they use to figure out what's wrong with the product, how to customize the product for a particular client, how to make the user interface more friendly, that kind of stuff. I worry a lot about that access to data because that could make my client a processor. And processors, although they don't have the lion's share of responsibility under these laws, they do have some. So the disclosure of personal data for the purposes of providing a product or service requested by the consumer. So if I'm selling on Amazon, for example, and I'm a drop shipper, and a customer buys from me, and I notify the supplier to ship the thing to the customer, that is exempt. The disclosure or transfer of personal data to an affiliate of the controller. I love that. We're going back 20 years from now, right? Remember I said one of the biggest holes that you could drive a truck through, but the law does require that you define very carefully who your affiliates are. They can't be just anybody that you come in contact with, anybody that offers you a nickel for people's information. Last, also disclosure or transfer that is part of a merger, acquisition, or other change of controls or transaction. So if you're in the process of selling your company, the data can definitely be transferred as part of that sale transaction. Okay, let's talk about processors now, because that's where most of you are going to be coming into play here. It's very unlikely that you're going to be a controller of data of consumer data, unless you are a consumer-facing company with lots of customers. You're much more likely to be considered a processor, someone who has access to a controller's consumer data. At what point, what do you have to do? Basically what you have to do is you have to basically work with the controller and help the controller comply with the Connecticut law. You are expected to assist them in their compliance efforts. There must be a contract that sets forth. If you are a consultant, sooner or later, you are going to be hit with a data security provision in a consulting contract. You're going to send your standard form of consulting contract out to the client. The client's going to come back, and lo and behold, there's going to be a data security provision in there saying that you will protect, their data, and there are 15 things you have to do. Okay. We'll talk a little bit later in the program about how you deal with that when you get that request, because I get my clients, I represent over 200 consultants around the country, and they are all getting hit with these now. Everybody wants to pass their responsibility for data privacy onto their suppliers, their vendors, is what's happening here. So they're saying you're a processor. Maybe you're not a processor, but if you sign a contract that says you're a processor, you're a processor. Okay, so the contract basically has to require, and frankly, most consulting contracts that I deal with are already somewhat compliant with this. The contract must require that the processor ensure that the data is subject to a duty of confidentiality, that they must delete or return the personal data at the controller. I mean, any standard confidentiality agreement has that clause in there. Makes available any information necessary for compliance to the controller. After complying, the controller with an opportunity to object, engage any subcontractor with a written contract that requires adherence. Keep this in mind. If you sign a contract with your client that says that you will keep their data confidential and you're using a subcontractor, this requires that you have a written subcontract agreement saying that the subcontractor will respect and honor those privacy obligations as well. Okay, and then allow and cooperate with reasonable data processing assessments. We'll talk about those in a minute. These are the duties of the processor. Basically, there's got to be a contract with the controller that says that you're aware that this consumer data is subject to protection and you will assist the controller in meeting their compliance obligations. Now, let's talk about what controllers have to do. Now, you can see there's a lot more here that controllers have to do, and I apologize for the tiny type, but I wanted to stay as close to the language of the statute as possible. First of all, you have to provide your consumers with a clear and meaningful privacy notice. And this is a little bit more detail than the privacy policy that you all used to do. You have to be a little bit more specific. Those of you who have seen a California form of privacy policy, Connecticut wants you to move more and more in that direction. They want you to have specific sections in there that say specifically the categories of data you process, the purpose for processing, instructions for consumers to exercise their rights, categories of personal data. You have to break it down by different categories, and the controller's contact information. You also must include a description of how consumers may submit opt-out and other requests. Okay. You also must limit your processing to the disclosed purposes. If you tell people you're going to disclose their data for purposes A, B, C, and D, you cannot use their data for purpose E until you amend your privacy policy and you get them to opt in. Sensitive data, there's a very special provision of the law that says that if you are dealing with sensitive data, like person's racial or ethnic origin, mental or physical health, sexual orientation, that kind of stuff, there are specific things that you have to do in your privacy policy to protect that. Those categories of information are subject to hyper regulation here. You basically can't do a lot with that information if you have it. And you have to be very, very careful to let consumers know that that data is going nowhere at all. Okay. Non-discrimination, you cannot discriminate against clients. So for example, if some of your clients have opted into your privacy rules and some of them have not, you cannot discriminate in any way in favor of the persons who have opted in. You can't do that. Irrevocable consent, you must provide consumers with an effective method to revoke consent that is as easy as the method that they use to provide the consent. So what this means is that it's somewhere on your site, you have to have a button. This is the infamous, if you know anything at all about the California law, California says you must have a button on the website, on the homepage, or otherwise in a convenient place that says, do not sell my data. And if you click that button, you are opting out of everything. Okay. Now, the Connecticut doesn't go quite so far, but they say that you must have an effective method to revoke consent. And what they're really saying is, if you do the California button, you're probably doing more than the law requires, but you're okay. Okay, the data protection assessment. We talked about this earlier. A controller has to conduct a data protection assessment of its organization for processing activities that present a heightened risk of harm to a consumer. So if you are engaging in any of these activities, if you are processing personal data for targeted advertising, if you are selling data, if you are processing sensitive data, race or ethnic origin, sex life, sexual orientation, that kind of thing, or processing personal data for profiling, where it involves, foreseeable risk of, the bottom line here is, if you are at all engaging in the activities that the law is most concerned about, you have to do an internal assessment. And while it doesn't have to be in writing, keep in mind that if the Attorney General comes after you, we'll talk about enforcement in a minute of how the law is being enforced. the first thing they're going to ask you to do is to produce a copy of your data protection assessment document. They're actually going to want to see an actual assessment document. So if you are doing any of these activities, it's probably best that you consult with an IT expert and start putting together a written assessment of your internal policies and what you do to protect the consumer data that's in your possession, for which you are a controller, because you are going to be asked for it, and you don't want to go scrambling to put one together if the Attorney General sends you a letter and wants a response in 10 days. Okay, how do consumers opt out? Okay, basically the Connecticut law requires that all controllers, again, the focus is on controllers, to provide a clear and conspicuous link on their website to enable a consumer to opt out. So while the Connecticut law does not prescribe what to do, clearly what they're looking for is the do not sell or share my personal information link, which is required by California's statute. Look at any website of a California company and you'll see it's right there on the home page, and sometimes it's a footer on every web page that says do not share. But they really want the consumer, they figure consumers are not professionals, they're not IT people, they don't understand a lot of these technical concepts. They want it to be real simple. Someone with a grade school education should be able to know how to opt out of they want to make it easy. They want you to make it easy for your clients and customers to opt out. Starting in 2025, controllers must allow consumers the option to opt out of targeted advertising and the sale of personal data, if you are doing those two things, through an opt-out preference signal sent with consumer consent via a platform. We're going to wait a little while on this. They have to develop regulations on this to tell us exactly what they're barking at here. But clearly, there are protocols that are being developed now online for opting out of things. And sooner or later, Connecticut's going to require that controllers adopt one or more of these methods for enabling consumers to opt out easily. We have a little time on this yet, but just keep in mind that it's hanging out there, and you want to keep informed of developments in this area of the law. Who enforces the law? There is no private right of action. Someone who's unhappy with your business can't just go get a lawyer and sue you for violating the Connecticut Data Privacy Act. That's one piece of good news here. None of the privacy laws have a private right of action. Basically, if somebody is really unhappy with what you're doing, or they think that you've sold their data inappropriately, they have to get the Connecticut Attorney General excited enough to do something about it. The Attorney General in Connecticut has the power to enforce the statute. Take a look at this. This is sort of interesting. The Attorney General's office has enforcement authority. They threw this in kind of at the end. And if you're not looking for it, but basically the data privacy law says that a violation of the data privacy law is also an unfair trade practice under CUTPA, the Connecticut Unfair Trade Practices Act. That was a little sneaky thing they did here to say, because if you know anything at all about CUTPA, they had that statute has incredible penalties and things like that for breach and whatnot. It basically gives the Attorney General power to develop regulations in this area that will also be considered violations under Connecticut's CUTPA statute. From July 23 to December of 24, the Attorney General just can't come after you. They have to provide you with a notice of alleged violations in a 60-day cure period, if a cure is possible. Beginning January 2025, this is when the full enforcement authority kicks in, and the Attorney General will be able to grant opportunities to cure in their discretion. In other words, until 2025, the AG's office has to give you a chance to cure if they discover that you've breached the statute. After 2025, any cure opportunity will be in the Attorney General's discretion, taking into account all these different factors. So clean up your act now is the message. Must I change my website? Now, again, Bud unfortunately is not here today. This is really his slide, but you probably don't have to change your website, but you need to make some changes to it. Definitely, you need to include the opt-out button and make it visible, make it conspicuous, make sure people can see it. People shouldn't have to think when clicking on this button. Turn tracking and retargeting pixels off. This is what targeted marketing is all about in the statute. If you're tracking people's, cell phone location, their geolocation, stuff like that, in order to sell them stuff, hey, we see you're right across the street from a deli that's, an advertiser of ours. Why don't you stop in and have a sandwich? If that's what you're doing, you got to stop. You got to basically stop doing it. Have a "we respect your privacy" statement that's easy to read and find. I've always been telling my clients for years, there should always be a link to the privacy policy, not just at the bottom of the homepage, but also at the bottom of all your internal pages as well. People should be able to find your privacy policy. I mean, it used to be that you kind of hid your privacy policy. You had to make people look for it, but that's no longer the case in states that are adopting these kinds of data privacy laws. They want people to be able to find them. How do you plan to verify for a customer that you deleted all of their personal information? This is, we said before, the statute and the other state statutes as well require that controllers especially delete any information if a consumer requests that. Well, okay, let's say they do, and let's say you do delete it. How can you verify that consumer data has been deleted? If you've ever dealt with a web designer before, you know that web data never really goes away. You can certainly delete something, but let's say you delete an email or something that's really important. You can call your web designer, and they have tools that can find emails that you have deleted even years ago. They can find this stuff. There are forensic people that do nothing but go into databases and stuff and track down information that the user thought they had deleted months or perhaps years ago. How much do you have to do? What I would suggest you do here is talk to your web designer or talk to Bud if you want to get a hold of him, and talk to him about specific ways in which you can make sure that the data is not just deleted from your computer, but is deleted also from any online database that may have kept it somewhere. Let's put it this way. I mean, yourself, if you've ever done like a TikTok video or something like that, if I take that download video and I download that to my computer now, and you delete it the next day, it still exists on my computer. Okay. How far do you have to go in deleting data? That's a question for Bud or for your web designer. Minimize the customer data you retain. I mean, there are services that will automatically delete and destroy things after a while. Take advantage of those services. Maybe you have to pay a few bucks a month for it. Do it, and make sure that you are not holding on to consumer data, especially if you're in the situation, if you are a processor where you only occasionally get screenshots of your customers' consumer data. Those should be deleted like immediately. As soon as the project is over, those things should be deleted, and make sure that you do it or get a third-party service that will automatically, delete all screenshot files or something like every 30 days or something like that. There are gray areas in data retention. Taxes. I'm giving you this link to an IRS webpage that talks about how long should you keep records. Generally, what I tell my clients is never throw away your old tax returns, the returns themselves. The backup for the returns, all the, the receipts and all that kind of stuff, you keep it for 6-7 years. The IRS, when they audit you, they usually go back 3 years. If they see evidence of intentionally withholding income, they can go back 6 years. 6 to 7 years should be pretty much safe for the backup, but you should never throw away the actual return. In 2005, I got a letter from the state of New York. Now, I hadn't lived in New York in ages. They had a fire in one of their upstate warehouses, and they couldn't find my 1973 New York State tax return. This is 2005, almost 25, or was it 30 years later. All right, they're asking me for a copy of a tax return that my dad prepared and filed when I was a sophomore in college. That's what happened. Well, you know what? I have copies of every tax return that I have ever filed. It sits in my attic in a file cabinet. I was able to produce the document, photocopy it, and send it to them with a nice letter basically saying, "In your face, Chucko." I love doing that. Okay. Don't ever throw away the returns, but the backup 6-7 years, medical and dental records, if you have health data of your clients, if you're a doctor, whatever, medical professional, it's 7 years by law in Connecticut. Medical, dental, all medical records must be kept for at least 7 years. I would keep them even longer, to be honest with you. What about New York? Okay, well, New York does not have a comprehensive data security statute like Connecticut does. That's good news. But they do have a statute that they passed a couple of years ago. They call it the SHIELD Act. I love it when they give these things acronyms. Stop hacks and improve electronic data security. There must be. This is what they must give the college kids who work as summer interns. They have to come up for names of all these silly statutes. It's not a full-blown data privacy law. It doesn't have specific rules for controllers and processors, which is what Connecticut and California and all the other 5 states do. It basically requires notification of a breach of security by any person conducting business where the compromised data is computerized data containing private information of a New York resident, or the compromised data is reasonably believed to have been accessed or acquired by a person without valid authorization. Basically, in New York, if you have personal data of New York consumers, and there's a breach, the SHIELD Act tells you what you have to do. It does require the companies to have a data security program with reasonable administrative, technical, and physical safeguards to protect private information. The statute, I didn't want to reproduce it here, but it basically lists 15 things you need to do to have a reasonable data security program. Basically, if you're doing data security assessments for the Connecticut statute, those probably should also comply with New York SHIELD law if you're dealing with information of New York consumers. Okay. Must you change your privacy policy? In a word, yes. I would say 95% of the privacy policies that I work with need some tweaking, are going to need some tweaking to account for the Connecticut statute. If you are subject to the law, you should add a section, and if you probably already have this already, you should add a section to your privacy policy headed to our Connecticut consumers. You should also have concessions saying to our California consumers, to our Virginia consumers, to our Colorado consumers, to our Utah. You probably already have this to a little extent for your California customers, saying, we recognize that you have rights under this statute. Here's what we do to comply, with it. If you do not regularly process consumer data, let's talk about this. If you do not regularly process consumer data in your business, talk to your attorney and put some language in there saying it's not clear that you are either a processor or a controller within the meaning of the law, but you will cooperate with any controller who requests that you comply with the law. And you will comply if you are advised by legal counsel that you are a processor within the meaning of the law. In other words, you can kind of take a buy on this and say, we're not really sure if we have to comply with this thing or not, but if we're told by an attorney that we have to, or if a controller tells us they want us to, we will. And that should be sufficient to pay the lip service to the law that you need to know. So if someone finds this thing, they're going to say, well, all right, they're not saying that they're not saying, well, we're not going to comply with this thing. But they're wrestling with it because we really don't know. In some cases, the definition of processor especially is very broad and it's very vague, and it may catch some people in a web that shouldn't be there. So don't be afraid to say, well, we really don't think that we have any liability under this law, but if we are told by counsel, we will do so. That's perfectly fine. Or if you want to be nice about it, and I would say that 90% of the websites that I've seen that have, these sections to our Connecticut customers do not have to comply. It's just they're doing it because they want to appear consumer friendly. They want to say, we don't really have to comply with this, but we're going to pay it lip service anyway. We'll comply with the key provisions of the law because we want our customers to feel comfortable that we're not going to be doing things with their data that we shouldn't be doing. Okay. Should I sign a customer clause? Okay. If you are a consultant, this is the most important slide in the presentation. And I apologize that it's coming so late. Okay. If your client is a data controller, they are sooner or later going to ask you to put language in your consulting agreement, or they may have a separate agreement called a data security agreement that they're going to want you to sign saying, hey, as part of our relationship, we may give you access to our consumer data? And if we do, here are the 45 things we want you to do with it. If you've ever dealt with a medical healthcare provider at all as a customer, they usually call this agreement a business associate agreement, because that's the technical term under HIPAA that you do, that says that if you have personal data, you will not do X, Y, or Z with it. If you do not have access to data of the client's consumer customers, add language. I always tell my clients to do this, requiring the client to notify you before sharing personal data. I put a clause in there saying you will not disclose personal data of your customers without notifying us first, at least 5 or 10 days, and give us a chance to figure out what the hell we have to do with this. Okay, that's one thing you should be doing. If the contract language requires you to take certain steps, don't assume that this is boilerplate language. Talk to Bud, talk to an IT person, and make sure that you have these in place. If you sign an agreement saying we've got these 15 protections in place and you do not, that is fraud. And that can not only get you sued for breach of contract, but it may expose you to a lot bigger liability for tortious damage, for fraud, for fraudulent misrepresentation. It is generally okay to sign language saying what you will do in the event of a data breach, but make sure you are technically prepared to do them and that you are not required to share data that would put you in breach of a confidentiality agreement that you have signed with somebody else. That's a thing we should another day. Okay. Should we get cybersecurity insurance? Yes, if you can afford it. I just bought a policy. Premiums for a solo business are usually in the $3,000 to $5,000 annual range. Be prepared for a cybersecurity audit by the insurer, or they usually hire an outside consultant to do this. They're going to ask you 20 different questions, and you got to come up with the right answers. The things that they're most concerned about are your emails encrypted? Does anyone accessing your website need to go through two-step authentication? Yeah, I know. I hate that too. We all hate two-step authentication, but cyber insurers do require that their clients, that their insureds have this protection, so that it's difficult for hackers and phishers to get access to your website. Do you regularly back up your data? Bud and I are on exactly the same page on this. We both insist on what we call three-step redundancy. If you're using Microsoft Office products, you have access to their OneDrive cloud database. Take advantage of it. Have your computer automatically backed up to OneDrive. I have it done every hour. It doesn't cost anything. If you buy the Office 365 suite, it automatically comes in as part of that. So make sure you have it. Secondly, pay some money and have an independent cloud backup, because anybody who gets access, if somebody hacks your Office 365, they have access to OneDrive too. So OneDrive is not enough. You have to have a separate one. I personally use a software called ibackup.com. It's $19.95 a month. All of these things are usually like $20-25 a month. Subscribe to one of these services and have your computer automatically once a day or twice a day back up everything to the cloud on iBackup, which is not accessible via Office 365. Someone who hacks into your Office setup will not be able to get to your iBackup or your paid account. That's a separate two-step authentication you have to do to get in there. And then last but not least, go to eBay or Amazon and buy an external hard drive. They cost about $50. It physically connects to your computer via a USB drive, and at least once a month, I do it once a week, back your whole freaking computer onto this external hard drive. They usually have like 50 gigabytes of memory, and then unplug the USB cord. So 3 steps of redundancy: 1, within your Microsoft Office; 2, an independent cloud backup; and 3, a physical independent backup that nobody online can get to. If you're doing those 3 things, you are doing as much as anybody can do to back up your data, and it is extremely important. Okay, so we're basically at the end. Here are the key takeaway points. Until we have a federal privacy law, and we may have one next year, depending on how Congress goes, anybody doing business online must determine their exposure to privacy laws in these 5 states: California, Colorado, Virginia, Utah, and now Connecticut. If you have nexus in Connecticut for sales and other taxes, and you have more than 100,000 customers who qualify as consumers or derive 25% or more of your gross revenue from selling data, you must comply with Connecticut's new law. The law does not cover most business-to-business or employer-employee data transfers or data that has been de-identified or statistically aggregated. Those are the key exceptions to the law. Consumers have the right to opt out of the processing of personal data for purposes of targeting advertising, the sale of personal data, or profiling. Controllers must post a clear and conspicuous opt-out button on their websites. They must respond to opt-out requests within 45 days. If a client asks you to sign a data security clause in their contract, review it with both your attorney and your IT people to make sure that you can comply with it. And last but not least, consider cybersecurity insurance. Yes, it's expensive, but the premiums are tax deductible. And with that, I am at an end. I know we started a little bit late, so I'm happy to go a couple of minutes over and take a couple of questions, Bob, if we have time. But this is how you contact me, and this is how you contact Bud. Any technical questions, call Bud. Any legal questions, call me. Bob, I think we're done for today.
Yeah, we are out of time, but we will just stay for a couple minutes because we do have some questions here that have come in. So we'll try and be as brief as we can. Here's one from Andrew Cliff. The Connecticut threshold, do they get triggered by the number of transactions or the percentage of revenue generated in Connecticut alone, or is it within the US or even worldwide?
Okay, well, first of all, Connecticut did not adopt a revenue threshold. Only California, of the 5 states that have adopted data privacy laws so far, has a revenue threshold of 25 million. Connecticut's law is solely based on the number of consumers that you have for whom you control data. That's the important thing. So if you're a data controller and you have more than, 100,000, consumers that you have personal data of, you have to comply with the law regardless of who those people are. It's not just Connecticut residents, it's anywhere. If you are of that size and you are a consumer-facing business, then you have to comply with the law. Connecticut doesn't go on the basis of the number of transactions that get involved. They focus on the number of consumers for whose data you have control of. I hope that was clear.
This one may be a little too specific, but it's from Julie. Do you have an example wording template for the website for the privacy policy with the new laws? And I know you spent time covering that.
Well, I hope you don't mind. I'm laughing because now remember what I said at the very beginning about the difference between legal information and legal advice? Okay, right. This is legal advice that you are asking for. And if you contact me, I'll be happy to look at your privacy policy and recommend changes. Of course, I will charge you something for that, which we will discuss when you speak to me. But this is a lot of the time. I spend a lot of my time with my web-based clients working on their privacy policy, their terms of service, to make sure that they are complying to the extent possible with the laws. And if they're not, having at least some information on there explaining why they feel that they don't have to. That's an important thing. You may not don't feel that you have to comply with the laws of all these 5 states if you're just a consultant that has 5 clients. But you should have something in your web documents that say, we do not think that we are a processor. However, if an attorney advises us that we should, we will, of course, comply with the law. That's the best approach that you can take.
Okay, Julie has a separate question, which may be more appropriate for Bud, but maybe you want to give it a try. If I use Dropbox to share folders with clients, what should I consider?
Yeah, I am not a big user of Dropbox. I'll be honest with you. I still do things pretty much the old-fashioned way with emails and with things like that, but it's tricky because you also have Dropbox's set of privacy rules too that you have to deal with here. But that's a question really for Bud, I think, because I know he's a Dropbox maven, so I would send him an email.
Yeah,
you have his email address right up there.
He would definitely be able to give you some input on that, Julie. We got a couple more. One from Crystal. If only collecting emails on a website does a CM, I'm assuming that means client management system, like Constant Contact, protect us enough?
Yeah. Well, again, it's not completely clear that by just getting an email from someone, you have personal data of that person. And again, if it's in a business context, you may be exempt from the statute. What I tell people is, first of all, you need to look at Constant Contact's privacy policy and see, what they say in terms of things like that. But in terms of it, I mean, I would say that if you're worried about whether you have hit the threshold to have to comply with any of these data privacy statutes, you should include emails and things that you get from Constant Contact. Constant Contact is a database of clients and customers and people that you come in contact with, just like Google. Oh God, I'm blanking out now. Google Contacts is the same thing. I mean, when I go to sell my law practice and people ask me, hey, Cliff, who are your clients? The first thing I'm going to do is give them access to my Google Clients or my Constant Contact folder that has all this information about it. So you do have to take it into account for purposes of determining your level of compliance. In other words, if you are dealing with emails via Constant Contact, you would be, and you meet the definition of a processor, you would be accountable as the processor, not Constant Contact. I think that's the question that you really want to ask here. So I think it's pretty clear.
Very, very helpful. Okay, one last question from Michael. Hi there. Just so I have this right, if a small business does not require those forming accounts on their website to have two-factor authentication, would that generally void our ability to receive monies for damages in the event of a hack? Would the same apply if we use an external service for account creation, that service would need to require or prompt the option for two-factor authentication for all our customers or clients? So I think this is related to the cyber insurance.
The cyber insurance. Well, first of all, if you are not using, you are only required to use two-step authentication if the cyber insurer requires you to have it as a condition of coverage. Most do. Just so you know, when you apply for cybersecurity, they're not just going to take your word for it that you have all these things in place. They're going to hire a consulting firm that's going to look at your site, and they're going to say, you need this, you need this, you need this. And if you don't put it in place, you don't get coverage. It's that simple. They can deny coverage based on this. I mean, I was told that I had to have my anyone who has access to my website, including my web designer. I've been using the same web designer for only 10 years. He's phenomenal, and I trust him like I trust anybody, to the extent that I trust anybody in this world. But they insisted that he not be able to access my site without two-step authentication, which he didn't have any problem with it. We did it, because I needed the coverage. I'm dealing with sensitive legal information. My Gmail folder contains sensitive information of clients. I am very worried about that stuff getting out there. If that stuff gets out there, not only have I breached my obligations to the client under a data privacy law, but I've also breached my obligation of confidentiality as a lawyer, and the client may not be able to have lawyer-client privilege. So because of that, I obsess about this stuff, probably more than most people do, but you should as well too. Increasingly, we are living in a world in which people have legal rights to their data. And you have to treat that stuff with respect and be able to document that you are treating that stuff with respect in order to avoid liability. We can't just get away with it, just paying it lip service like we did, 10 or 20 years ago when the internet first burst on our conscience. So that's the message.
Okay, thanks, Cliff. I think we're going to have to cut it there. Just quickly to wrap up, as a reminder, the webinar was recorded, and those materials should be available within the next day or so on our website, fairfieldcounty.score.org, and you can reach them by clicking on demand. Again, if you wanted to access the individual counseling, you can do that using the yellow bit.ly link or clicking on the request a mentor link on our website. And on behalf of the Connecticut District of SCORE, I'd like to thank everyone for attending today's live webinar, and a special thank you to Cliff for presenting, and to Bud for his contribution to today's presentation. So stay well, everyone, and enjoy the rest of your day. Thanks, Cliff.
Thank you. A pleasure as always.